anybody who's not presenting to go ahead and just turn off
the video
and audio, please.
Yeah. We'll just mute it.
Okay. Welcome to our afternoon of legal counsel, as we might say. Healthcare Law Partners presentation for a lunch and learn legal lesson. And today we're going to talk about the 5 great checklists for in-house counselors and administrators. And for those who deal with in-house counselors and administrators, it's nice to know what's going on. And with that, again, it's presented by South Florida Hospital News and Healthcare Report. And we do this the first and third Tuesday at lunch of every month. And Ben, who's the lead attorney, will go ahead and tell you a little bit more about it. I'll turn it over to Ben, and I'm going to go silent on this. Ben, it's all yours.
All right, thanks. Hi, guys. My name is Ben Mirza, and today we're going to talk about 5 great checklists for in-house counsel and administrators. And the reason why you see in-house counsels and administrators is because actually I think that there's a use for both types of functions for these checklists. And we'll so why are you here today, right? So let's talk about that. When legal contracts go awry, that's when you look back and you go, man, I should have had a checklist for that. We had one situation where a 10-minute review turned into a 10-hour job. And that was really an online agreement that one of the physicians had called us up and said, hey, can you review this online agreement for me that I want subscribers to just subscribe to? And, it's just a quick review. It's already been put together. Can you help us through it? No problem. So, the 10-minute review turns into a 10-hour job because that physician practitioner, physicianpreneur had not thought through all of the different applications that could go into a health counseling agreement, right? So you could have individual end patients that are going to ask for it. You could have employers who want to have a counseling agreement for their employees. You could have health insurance plans that could want their members to be a part of that. And he really wanted that whole broader application for this. And, before you knew it, the 10-minute job did turn into 10 hours. And you can see how the scope of that work literally starts to expand as you start to bring on the different types of ways of applying that agreement. And, so today what we're going to walk you through is going to help you curtail some of that. It's going to help you keep that 10-minute review closer to a 10-minute review. It may not be a 10-minute review, but it's going to help you save resources on as far as legal money that you're spending, and as far as your own time goes. It's going to help you save both on time and money. So that's one way. Another way that we believe that these checklists are going to help you is when can contracts come back to haunt you? There are different ways that it happens. And yesterday, as we were preparing for this, Ed had a really great idea. Go ahead, Ed.
Yeah. So keep in mind that in an organization, executives come and go. I mean, executives are here, they may move positions or move to different companies. It's just important to really have a checklist of what the important contracts are and what's in those important contracts. For example, a restrictive covenant. I remember several years ago, I was dealing with a hospital physician arrangement. That hospital physician arrangement had a restrictive covenant where the physician organization couldn't provide, or its affiliate couldn't provide work within similar services in a competing hospital within a 20-30 mile range. People forget about those things, and so all of a sudden an affiliate, they say, well, let's provide services at another hospital within that range, and they don't remember it, so they go down the line, the recruiting and whatnot, and all of a sudden the hospital with a restricted covenant says, hey, wait a second, why are you guys doing this? So those are, again, an example of how a contract that has some provision may come back and haunt you all in the future. So it's just important to keep all these things as we go through these checklists in mind, so that you don't trip up.
In one instance, I was actually dealing with with after a contract blew up, when it did come back to haunt the actual building owner. It was a medical office building with on contract for just installing a water heater, a $500-600 water heater Nobody ever thinks about doing much of a diligence on that. Nobody thinks about doing an actual contract for that, and neither would I suggest it on a $500-600 contract. But those contracts can come back to haunt you. In this particular instance, it was the plumber comes in with the actual water heater to be installed like on the 10th floor of a building, and as he goes in to go install it, he goes into the actual water closet, undoes the stuff, and as he's undoing it, there's actually another pipe right next to the water heater. There's another pipe, and he happens to just hit it in the right way, and that pipe breaks. And it was the actual pressurized pipe that goes from down, from ground up to the actual rooftop for an air conditioning system. And that pressurized pipe pushed out so much water that the water just went right into every single unit, went into the elevators, stalled out the elevators, and just killed business for a long time. So you can have a contract go bad, even though it seems like a $500 contract. So today, what we're going to talk about is do some of the basic, logical, commonsensical sort of things as well, even when you're entering into something that doesn't require a lawyer's approval. So that makes for interesting situations for us.
And keep in mind, this presentation is not intended, it's intended for general informational educational purposes. We're not providing legal advice. And that this forum is open, live, and being recorded for use as an open platform on online resources. Just please keep that in mind.
Just a quick review of what we do and what we've done in the past. I have degrees from several different disciplines, starting off with accounting, law, obviously, and also in corporate mergers and acquisitions. There's also I also have a master's of public health administration, and I've done about I'd say probably 3 billion, maybe more dollars worth of contracts. And just to kind of put that in context for you, some of these healthcare construction contracts, some of these cafeteria, even maintenance sort of contracts, they can range in the hundreds of millions of dollars. And when you actually look at that as a repeat cycle, it's worth well into the billions. And I'm sure this is an underestimate, but it's sizable. And the kind of things that we touch as administrators and as legal counsels, you got to be mindful of. That's why it becomes really important as to how you develop your checklist, because you may be launching off a contract that's got billions of dollars behind it and not even really thinking through the whole situation. So Ed?
Right. Yeah. So I'm Ed Meyer. I'm of counsel to Healthcare Law Partners. I am licensed in California. I'm not licensed in Florida. So I provide service on a federal law level to clients. Or if you're a Californian, I'll provide California services. I'm in my 30th year of practicing healthcare law. I've represented a wide variety of healthcare providers, from large hospital systems to individual hospitals to individual physicians to large physician groups, national physician groups. I was recently at Mednex there in Sunrise, but in their in their Texas office. I started my career actually working for a member of the House Ways and Means Committee as we were writing some of these statutes, then worked in the U.S. Department of Health and Human Services as the appointee in the Reagan administration. So even was a compliance officer for a period of time at a small hospital. I try to bring that into my work. Komal? Muted? Yes.
My name is Komal Mirza. As Ben forgot to mention, I am actually his niece, so we've known each other for quite some time. That also
what?
You don't let me forget.
That also makes me the youngest member of this group, but that doesn't mean that I haven't gotten my feet wet. I have helped primarily practice groups set up their corporations and begin facilitating practice. And my primary focus is in employment law, and I particularly am interested in non-compete agreements and navigating those. Those actually tend to be very cerebral and kind of help you, figure out how to navigate those and avoid them. This particular presentation was fun for us to put together because largely when I started practicing a few years ago, I'm actually now considered no longer a young lawyer. But when I started practicing, my primary tool was to create these sorts of checklists. It's a great resource, and I hope that you pick up some great pointers.
Thanks. Thanks, Komal, and thank you, Yoda. Ed's our Yoda of the group. He's been around longer than dirt, you know. So, all right, here we go. Let's get started. So let's talk about let's start off with like we do in all of our presentations. We start off with actually market forces. Legal departments today are under pressure for saving time as well as costs, right? So how do you move faster and and consume lesser resources? Well, the way you do it obviously is to actually have a checklist. And how do you decrease failures of contracts that occur later on down the line? You do it through creating a checklist. Checklist will help you get your way through a lot of things. You know, it's the space shuttle. Literally, that program is built off of checklists of checklists of checklists. You know, if they can do it, why can't we do it in law? That's the one thing that I think us as lawyers, we really probably need to actually give it more attention. But, you know, for me, it came naturally only because I'm used to dealing in like accounting principles as well as Excel spreadsheets. So I am a big fan of checklists. What it will help people avoid is, if you actually do it right, is it'll help you weed out the bad business partners. It'll help you iron out the right scope of services, so it's not a nebulous sort of a contract and nothing was really promised in it. You know, it keeps you from it helps you establish actually really great milestones with corresponding payment structures. And you know, and it also gives you teeth when something goes wrong in terms of recourse and liability. So, you know, as you go through this, I want you to think about the 3 most common contracts that you use in your practice, and do you have a checklist for that? And are you following it? Are you using it? Because there's a whole difference between when you're actually using a checklist and when you're not. You can have it, but are you using it? Big difference. So with that said, today we're going to talk about the essentials of checklists and how this particular presentation was inspired, and it'll give you the context of where we're headed. Then what we're going to do is we're going to walk you through the kinds of questions the CEOs would typically ask of the legal departments, and it only behooves administrators to understand the same things, right? Either they're following in the legal path or they're following in the administrator's path. But if the CEO is concerned, everybody under him or her needs to be concerned about the same thing that she may be concerned about.
Because as administrators and attorneys, we are service providers. In many ways, we're service providers to the CEO, and having an understanding of the priorities of a CEO helps us provide services, you know, more efficiently and, you know, and holistically.
Yeah, true. And then the other thing that we're going to talk about is the often overlooked provisions of typical contracts that, you know, Ed and I and Komal, we think are important. We'll walk you through a fair market valuation checklist. We'll walk you through a Stark analysis checklist, and then something that's not on here, we're gonna provide you a checklist of checklists. And you know, that's kind of how you build your practice. That's how you make sure that you're effective with your clients, and that's what we do. So I'll start off with this. This seminar was actually inspired by this book, the Checklist Manifesto. It's on the actual New York Times bestseller list. But the author basically talks about human structures, like you see down here on the left-hand side, and then it talks about hospital structures, like hospital building structures. And his argument is something as complex as operating inside a human being, it requires a checklist. Something as complex as building a mini city of like a hospital, which has cafeterias and waste disposal systems and cooling systems and so forth, and you know, different places to contain certain things, from the morgue to the, you know, the ICU. You know, why would you not have checklists for your own business and your own practice? So in law, we look at checklists as really being able to help us pick the right partners, you know, or when you're going after opposing parties, like you want to go and scope out who the opposing party is. And there's a whole checklist for that sort of stuff. There's a checklist for your statement of work. There are a checklist for the kinds of risks that you're willing to entertain. Even in litigation, there's checklists for filing a claim. You got to go through the different types of claims. Did you raise all of the claims that you were entitled to against the opposing side or not? We go through that sort of stuff, including defenses. When you're defending somebody, how do you defend it and make sure that you invoked everybody, right? So what you want to do is you want to make sure you incorporate a checklist where it's possible. What it's going to help you do is three things. One is it's going to add to your completeness of what you do. It's going to add to the accuracy of what you do, and it's going to lessen your worries. So us as counsels, if you're not a worry ward, I'm not so sure you're exactly built for the actual legal side of things, right? So it's going to help you lessen your worries, because majority of us are worriers, and on the legal side of things. But these checklists will help you reduce those worries. Anything else you want to add to that?
Yeah. Keep in mind the way physicians and healthcare systems operate is they're operating in teams, right? You have the specialist team, you have the general practitioner, you have the RNs, the extenders. All those are teams that are treating the particular patient, and effectively they're working through checklists. The medical record kind of is a way as a checklist. And when one team member goes in, they add information to that checklist. They then hand off the care to the next specialist that goes in, so they know the continuum of what's been happening with the patient. And we sort of, and preparing this presentation, we kind of thought through, that's something that lawyers kind of don't necessarily, or certain transactions, I just say, don't necessarily do. For example, a perfect example would be the handoff from the acquisition team when one's hiring a team of lawyers or have in-house counsel dealing with the acquisition of physician group. So they go and they do their due diligence, they negotiate the contract, they have discussions with the other side, and they end up closing the deal and accomplishing the transaction. And then that team says, wipe your hands, they go, now I'll go on to the next thing. They hand it off to the operating folks to operate, but there's not necessarily always an efficient handoff, because that whole due diligence factor has had effectively a lot of information that would be helpful for the operations, like ongoing operations. So it's important to, when you're thinking checklists, to think through what is it that set of team has done, and is that information being transferred over to the new set of operators, so they know and have a history and understand the key issues that came up, or and little landmines that were discussed as they were doing the transaction.
That's a really good point, Ed. And just to add one more thing to that is, if you take a look at information technology and how information technology can, as technical as it is, you can mess things up as soon as there's like handoff. If you don't have the fields merging the right way, uploading the right way, your records can get messed up. And with that, you can see its trickle effect down the road from there to the health professional to the patient care, if the fields just don't interact properly. So these checklists are important all the way around, whether you use them in IT or you use them in law. So with that said, now we're going to start off with actually the overview, right? The overview, and we're going to start off with the mind of a healthcare CEO. And this is essentially a checklist of what they're thinking about. If you notice to the left, there's a picture of Jeff Bezos with like different parts of the brain, right? And in it, there's even, actually it was funny because when you blow that up and you look at it, there's one that says how to leave Earth, how to get to a different planet, but really, a more realistic CEO for our environment would be somebody more like Bernard Tyson, the late Bernard Tyson. He was the president or the CEO of actually Kaiser Permanente. And what are these guys thinking about? What they're really thinking about can be described in four broad categories. One is governance, public trust, external outreach and strategy that kind of goes hand in hand, and the operational concerns that they live in. First and foremost is governance. Governance has it's the overarching goals of the organization. So they're really in depth and in sync with that. And with that, they have to bring their board of directors to be in sync with that, their shareholders, if they have shareholders. And, they've got to really understand the bylaws and the medical staff bylaws. So what's going to happen is, as in-house administrators or legal counsels, a CEO is going to want to turn to you and is going to ask you questions about, hey, how do I do this? What do you think about doing it this way or that way? You got to have an idea of where we're headed with all of these different things. So here's a checklist for general counsels to take a look at the mission, the charter, the culture. Take a look at the IRS not-for-profit filings that were done. Take a look at the medical staff bylaws that are in play that are going to affect so much of the business that's going on, because the CEO is going to turn around and ask you one of these days, hey, how should we navigate this? What do you think about option 1, 2, or 3? The second thing that a CEO is often concerned about is the public trust. And the public trust often starts off with the financial health of the organization, and which is often indicated in the actual debt ratings. They are concerned about the fairness of patients, the fairness of employees, the regulatory issues that are lurking underneath, right? Because every healthcare organization has regulatory issues. It's just whether they're being brought to light and worked on and resolved or not, right? So they will be concerned about what are those potential things that could actually blow up. And nowadays in this environment, equity and inclusion has become at the forefront, right? Just today, there was some sort of a post in the paper about Dr. Seuss books being taken off the shelves, and it's about equity and inclusion, right? So if you're seeing it affect children's books, it's affecting healthcare, guys. So keep that in mind. That's where the CEO's mind is. Also today with the COVID stuff that's going on, before everybody was worried about infections and how to preventing infections, but now it's all about vaccination. So the mind has kind of shifted for a CEO. How are we partnering with people to do vaccinations effectively? Are those partnerships, working for us in our patient base? They are looking at governmental mandates. They are looking at reimbursements and competition. Who is out there in competition with the organization that in-house legal counsels perceive as competition? They are looking at large employers in their geographical areas, because those are, again, patient catchment areas, right? Those market dynamics that are in place are important to a CEO. So they want to understand what everybody else is doing too. Last but not least, it's the operational concerns. If you have a community that's got a higher need for one service line or the other, are you providing those service lines? If you have a interventional cardiology program, is it time to maybe think about an interventional nephrology program? Is that service line being offered by your organization? They're looking at health, access to care. They're looking at technology. How easy is it for patients to come in and engage your company? So they're concerned about that.
And as I mentioned earlier, again, the purpose of this checklist is to realize that we as a council or you all as administrators are service providers. So to be able to be a better service provider, having understanding of those priorities and those things that are going through the mind of a CEO allows you all to answer questions by keeping all these pieces in mind. They're not necessarily linear. They're all moving around at the same time. And so as you look at, a particular question, you're thinking the medical staff, how does it affect the medical staff? How does it affect the bylaws? How does this affect the compliance, public trust issues? What are the government mandates, et cetera, what are in there? And what are the, what service line, how does it affect financials? All these pieces come together in reviewing and looking at and answering questions and assisting in strategy.
Yeah, good point. And I think practice tip, like what Ed was saying, is know your governing documents, know your major contracts, know your reimbursement contracts, know your health plan documents, know your government documents, right? Understand physician relationships and the contracts that actually guide those physician relationships. Understand the strategic partnerships that you've taken on. Know where you are in the scheme of things. And this is the kind of stuff a CEO will actually ask somebody that's in the legal department right off the bat and say, hey, what do you think? And, hopefully the answer off the top of your head. And if you don't, go back and check it because that's the way we've always run our legal departments.
Yeah.
This next section, so here's a Mark Cuban quote, right? So he's basically talking about know your business. If you know your business, you can minimize the risk. And I think a big part of lawyering and a big part of administrating healthcare is to know your business. You know, when we look at it from a contractual perspective, you know, we start off with, is it a brand new relationship, which we'll treat completely differently than if it was an amendment to an existing relationship, and which we will completely also treat differently from a renewal. So for us, we start off with that sort of a frame mindset, and then you want to know who's on the other side. So we actually have like a due diligence sort of a checklist. It's a quick due diligence checklist. Did you go to Sunbiz? Did you do a background check? Did you figure out who's employed under this this environment? Who has the authority to sign on the other side? You want to do those basic checks right up front, so you're not like, you know, spending time looking for them later on, because that's how you waste time and the back and forth that goes, right? The other thing that you want to look at it is it a focus or a non-focus arrangement? You know, focus and non-focus arrangement obviously involves, you know, government payments or Medicare, Medicaid payments, and specifically. And you want to understand that. You want to know who is your client. So if you're an administrator or you're a legal counsel, internal, you have clients. You want to understand who those clients are. You may have an actual user, and you may have a pair, which may be two different people. You may need to get that contract approved by both, not just, you know, the user and the pair. So it may be your CFO. You know, so take a look at that. Now, know who the competitors are in that particular business dynamic that's about to take place. You would treat a contract completely differently if it was a single source contract versus multiple sources. If you have only one person offering that particular product in the marketplace, you treat it with much more kid gloves sort of stuff. But if you have 5 competing competitors in that same marketplace, no, you know what? It's only as good as the next guy, right? So you know the competitors that are in this marketplace. Me as an attorney, I want to know that, because then I want to know whose chops am I going to bust, or am I just going to tap them, right? There's a big difference in that. Ed, you want to add anything to this?
Well, yeah, on the deal breakers and deal must-haves. Obviously, in entering a negotiation, you need to know from your client what are the deal breakers, what do they must have. But in the course of the negotiations, you may get to let's say a deal breaker or a deal must-have, and you obviously want to go back to the client to make sure if that really is a true deal breaker must-have, given to where the status of these negotiations are, because those negotiations may have given benefits that weren't foreseen, and that sort of changes the dynamic. And I remember a matter I was dealing with many years ago, negotiating a settlement on an antitrust claim where my client had to pay out, and the CEO gave instructions that this is the most money, you know, this is the limit of what I'll pay out. And as we negotiated and get to that limit, I realized it wasn't going to go any further. So instead of it walking away, we went back to the CEO and said, well, this is where we are. It's about to break down. He goes, well, okay, I'll tell you what, I actually didn't give you the real number, because I know if I gave you the real number, you'd end up at that number. So I'll authorize you to go a little bit further. So, you know, again, it's that communication that's real important in these negotiations.
That's exactly right, Ed. I mean, I'm actually in the middle of a negotiation of an employment contract, and my client's baseline has pretty much changed given the benefits that he's receiving from his employer. So all of these, you know, these deal breakers and these must-haves are constantly changing in that realm.
Right.
You want to make sure that you do maintain an open communication.
You know, the other thing that I also look for is I want to know what the oral representations are that are being made, right? So, like, for example, in like Homel's case, if that physician is being promised something orally, are they delivering it in the contract? Are they saying that that's actually happening? So like representations and warranties make a whole big difference to me. If a vendor is saying, you know, we will deliver in 2 hours versus 2 days, that's very different, right? What does it say in the agreement itself? And is that 2 hour delivery critical to you, or is 2 days okay? If 2 days is okay, then we obviously wouldn't touch it. But you want to know that, work product is often another concern. Who owns the actual work product that vendor or that outside contractor is doing for you? Who's got rights to it? Staging of milestones becomes really important in this. And you want to look at these. You want to know these ideas and business thoughts and configurations ahead of time, because what will happen is your milestones are going to determine your payment structure. Your payment structure is going to be either fixed, hourly, or variable, right? And if it's variable, when are they due? When is the hourly fee due? When is the fixed fee due? Are you going to do 10%, 20%, 50%, and then the balance at the end? I mean, how are you going to, structure those payments? And then what I always look at is, and I learned this a long time ago, by the former CEO of actually Excel Energy, and his name is Ben Folk, and he used to always tell me, you should always know the exit strategy in any contract. You should know when you're able to break it. So what if nothing goes right? If nothing goes right, what are you going to be able to do? And as an administrator, it is absolutely critical to know that. What are you in it for? Are you going to get penalized in the end, or are you going to be able to break it off immediately, or with a 30-day notice, or with a 1-year notice? We've seen contracts that go out to a year plus of notice requirement before you can terminate. Is that really a termination? I mean, it's debatable, right?
And also, I guess it reminds me of what my father used to say. My late father used to say, it's when you're looking at something, is you look at a transaction, that's what's the worst that could happen, and if you could tolerate the worst, because let's say your contract, you've drafted it enough to be able to tolerate the worst, then you can make a decision. But thinking through that.
Yeah, very true, very true. Now, the one thing that we use oftentimes is, if there's a one-off contract that is not in our library templates, we try to use actually a library of templates, so we can save time not only for ourselves but for our clients, and money, right? But what if in your library of templates you don't have a particular type of template? One of the questions that we will ask our clients, and I would suggest to you to do the same, is ask them, do you have a contract that you like, that you've seen in play? You can actually take that contract and see if it works for your organization. It would, you'll either improve on it, you'll cut it back, you'll either increase certain areas, but it still needs work. But at the end of the day, you don't want to start something from scratch, because ultimately that's what you're getting benchmarked on. Was I efficient? Was I effective? So copying in that context is actually a good thing. We will take contracts that are already in play and we will use them. Obviously, you got to
recreate the wheel.
Yeah. You don't want to recreate the wheel, but you also don't want to fall under something that hasn't been vetted the right way.
Yeah, you don't want a wheel that doesn't fit, by the way. So you got to make sure that wheel fits, right?
So, as we were talking, we were talking about what are some of the overlooked provisions in a lot of these checklists when you look at a contract. Well, here's just a handful that we came up with, and there's a lot more, frankly. But you want to take a look at certain provisions. What are they specifically saying? Now, these are very technical, so it's usually the legal department that gets involved, and they go hand in hand with the administrators to figure them out. But you'll have indemnification, release, and waiver clauses, and those could each be individually and separately, and there's multiple forms of them. What level of indemnification is okay? Like, for example, we've seen in inspection agreements that we are not responsible for any subsequent damages that come out of our inspection, but you're limited to the amount of fees you paid us, right, Ed? And
so you pay $500 for the inspection, but they don't catch something, and it's cost you $50,000. Well, if you have that limited to $500, that's all you're going to get, if that's what you contractually agreed to. So you just got to, and they have insurance already on that. So why would you do that? So you have to be careful. There's hidden landmines in these overlooked provisions. Yeah. I mean, similarly, like insurance provisions. So an insurance provision, keep in mind, an insurance provision is important, obviously, but over over describing the insurances that are already in place can actually give a roadmap to a plaintiff's attorney who gets a hold of the contract. That's then that it describes, they know how much to sue for and what different claims to make because they have it all there. Obviously you want to have insurance, but you have to make sure if your insurance obligations that you have there. So, as similarly, reps and warranties. Are you can you rep and warrant what's actually being done? Are you or do you really know what you're rep and warranting? Do you have or is just do you have the knowledge sufficient to be able to make that?
Changes in law provision. Now that's another provision you can have, that you can actually renegotiate a contract if the laws underlying the agreement or affecting the agreement change. In some contracts, you may not want that because you may actually want to be able to just straight up terminate that contract, or hold the other party to hold the other party's feet to the fire. Changes in law provision, you use it, but you don't use it all the time either. You got to use it under the right situation.
And the medical due process rules. Oftentimes these coverage agreements, they're basically requiring the group to waive due process. That they may already have. For example, they'll say, if certain things occur, the physician, the CEO of the hospital can say, I no longer want that person to be providing services to this. And if that hospital is really the only source of work for the employed physician, and there's no due process at all, you may end up not having a physician employee that you have to continue to employ because they have, you don't have a reason to terminate them if your employment contract doesn't cover that. And then you have to figure out what to do if you still have the payment obligations to the physician. So, those medical staff due process provisions that are in coverage agreements need to be looked at carefully and see if there is, let's say, if the CEO wants to exercise that right, is there an ability to go back and discuss again the issue, and sort of providing some sort of rebuilt due process provision.
And you also want to make sure to go back and review these clauses or these checklists as your business or your practice develops and evolves. What you start out with on year 1 may not be the same thing that you need to be looking for in year 5 or 10.
Good point.
Yeah, that's a good point. As far as requests for proposals go, one of the things that I often see overlooked in a request for proposal related contracts, when they actually take a request for proposal and response and turn it into a contract, is that the request for that contract doesn't refer back to the actual response. A lot of times what vendors will do is they will promise you the world in their response, but when it comes time to contracting, that promising the world is no longer in there. So one of the things that we'll do is we'll actually attach that as an exhibit to the actual contract and take the pieces and parts of it that work in our favor on behalf of the client. So attaching the actual response is hugely important in an RFP contract. And I don't know why more people don't do it. It makes no sense to me, but that's how I would do it. All right, let's talk about the fair market value process checklist. So again, whenever you have a fair market value that you need on a particular contract, it all starts off with understanding your client and what's being exchanged, the exchange for the exchange, the goods and valuable services that are being exchanged. Anything of value is deemed a part of the exchange. So, understanding that client situation is really important, and you have to be able to then convey that to your fair market value professional. And, fair market value professionals are often, they have their certifications. They could even be CPAs. But, not all of them are made the same way. You got to take a look at the experience that they have and the certifications that they have. And then if they have the experience, then does an FMV report actually satisfy what you're looking for? And we'll walk you through that in just a little bit as to what you're looking for in the FMV report. What you want to do is then you want to convey the transaction to the FMV professional so they have the full picture of what you're asking them to opine on. Like, for example, when you look at a lease, right, a medical office building lease, A lot of medical offices have a valet services. Was the valet services considered a part of the lease rate that was being fair market valued, right? So if you have a valet service or not a valet service, it can make a difference on, $25 a square foot to $35 a square foot. If the landlord is providing medical waste removal, like for example the sharps containers, again, that's going to add an incremental cost to the per square foot rate. Did your FMV consultant take those kinds of things into consideration? Even internet. Some medical office buildings will actually give out free internet to their tenants, and maybe even to the general public. Does that have a value, or does it not have a value? The FMV professional needs to know about those things. And they also need to understand what kinds of free products and things are being exchanged. You try to stay away from actually free products. You try not to do that. And if there's a bundling of products, and then that actually requires a further breakdown. The FMV professional needs to know and understand that. Ed, you want to speak a little bit about the physician compensation FMVs?
Yeah. So in the physician compensation FMV, you want to make sure that all the compensation is described, how it's described, and that it runs to the actual services and it's weighing those services. So, for example, in a medical director arrangement, a physician will often say, well, as a professional, I provide professional services, and my effective hourly rate for providing care to patients is X dollars. Let's say it's $300 an hour. So he says, I want to be paying $300 an hour for me doing the administrative side of the medical director agreement. Well, the government will look at that and go, wait a second, you're valuing administrative services. Is the FMV for an administrative service maybe a whole lot less than the professional service? But if you're trying to match those up, you want to articulate if it's factually correct that doing this particular medical director service really requires additional higher levels of acuity of understanding and education and background to warrant a higher evaluation. But those are all discussions that need to be going on with the evaluation consultant.
Yeah. And then when you get the final report from the FMV consultant, you want to make sure that it's got certain critical items in it. You want to make sure that it's got a definition of Stark in it. You want to make sure that it's got commercial reasonableness tackled in it, and the business necessity elements, right? So commercial reasonableness is another level that the OIG is looking for to make sure that something was commercially reasonable, that you did it. Sometimes it's usually at a profit that you did something commercially reasonable, but it can also be at a loss. So not everything has to have a profit motive, but majority of the things probably will. In the FMV report, you're also looking for the standards that were applied in coming up with that FMV opinion. Those standards have to be articulated.
Yeah.
How was it described by the different disciplines? And in the report, you're also looking for what was the exchange, what was deemed to be of value to both sides, and does it meet those requirements, including things like free product or RVU considerations that were given. It's really so a practice tip on this slide is read and review your fair market value report to make sure that it's including these things. And like Ed mentioned earlier, some of these extraneous duties that the physicians will pick up, make sure that that's included in the FMV report, because that's how you get to a fair market value opinion, right?
Yeah.
It's a total holistic.
And one other point I want to make is, and this goes back to that very, very first point on the FMV professionals. Having an FMV professional that actually understands healthcare and healthcare regulation is very important, because a general FMV professional who doesn't deal with healthcare may include in fair market value calculations, let's say the business that'll be generated. Because let's say when you're buying a business, you'll look at the business being generated outside the healthcare field. But when you include that in the valuation, you may very well be tripping up the anti-referral laws, the kickback rules. You're paying for business being generated as opposed to looking at more like what do people generally pay for this type of service line. And again, one last little comment on that. Keep in mind what the CMS said in the preamble to the new Stark regulations that came out in December, that became effective on the 19th of last month, and that is, I'm sorry, 19th of January, that it's the financial arrangement that's being reviewed for Stark law purposes is the actual arrangement that is in place, not necessarily what's in writing, but what actually the services are being done and the compensation that's being gone to. So that FMV valuation report needs to really reflect what's actually being done, as the contract needs to really reflect what's being done, what's being paid for, and all those elements.
Good point. Okay, so we have 3 more slides left, guys. So what we're going to do is we're going to speed it up a little bit, and hope, because it's kind of getting late, right? So it's about,
Right.
yeah. Okay, so here's a compliance checklist. And I think what you do is every time you have a compliance scenario, you want to take a look at the type of organization that you're looking at. The size actually matters. A corporate structure actually matters. Just keep this in mind. If your practice is big enough, like you're going to deal with a 10-person organization completely differently than something obviously a lot larger, right? So in a larger organization, and that's a context we're going to drive this slide through, in a larger context, the chief compliance officer has to be independent. They have to have a direct reporting line to the board of directors, and often they'll have a dotted line over to the legal counsel because they gotta coordinate issues, right? So size actually matters. The compliance department has to follow the flow of money, and they have to follow the flow of information. Are things being complied with when there's a flow of money and information? When compliance goes into action in several different areas. One is when you're onboarding a professional. Are you going through your compliance onboarding standards, right? Did you do the credentialing? Did you do the vetting? Did you do the conflicts of interest form? When you're contracting, you're going to do the same sort of stuff, right? Including the conflicts of interest forms, and you're going to have them fill them out. When it comes to coding and billing, you got to have compliance that's actually auditing coding and billing. When it comes to auditing itself, your auditing and compliance committee, that's where all of your compliance issues are going to get reported eventually. You'll resolve what you can resolve, but when you need to bring something that happened that was critical and could affect the organization, you got to bring it up to the audit or the compliance committee. Again, just remember, not all compliance programs are equal. They will be multifaceted, very different for the different types of organizations. You could have anywhere from a multi-hospital arrangement to a physician practice area. But even if you look at that, you're going to treat a hospital that's a teaching hospital completely differently than you would a non-teaching hospital, a rural hospital versus an urban hospital. Your compliance checklist will vary. It will also vary on the practice group. If you have a family practice group versus a surgical practice, right? They will have different types of checklists. It will not be the same. You'll be uniquely suited for that environment. Whether you look at nursing homes or home health, two very different, it sounds the same, but it's very different delivery and mechanisms that are in play. So just keep that in mind. Compliance has to be unique. Next thing we're going to touch on is internal guidance. On internal guidance, you want to make sure that you've got your codes of conduct, your policies and procedures in place. Specifically, as a compliance officer, I would be looking for conflicts of interest form. I would be looking for auditing and monitoring of transactions. I would be looking for gifts policies and records retention policies. How are those being complied with and adhered to? Is there adherence to any of these policies or not? Who's doing that checking? Last but not least, legal and compliance have to literally work hand in hand when it comes to this. If there is an internal investigation, as Ed will tell you, he and I have investigated internal investigation sort of issues, and we will go through whether the facts match the law, and if they don't, how are we going to make sure that the facts do actually comport with the law and you're no longer out of compliance. With that, when you invoke a legal counsel, is attorney-client privilege at play? It's kind of a yes or no question. Ed, you want to elaborate some on that?
Yeah, because attorney-client privilege applies to when say internal client is asking a legal question, asking for legal advice, and when the compliance function, those are not privileged. Effectively, when you're doing generally compliance function, and you want to be able to show the government as you have a bona fide compliance program. So the government's going to be interested in, are you hiding the ball? Are you using legal counsel to basically hide the operation of the compliance functions? You have to be careful and draw the careful line between what is truly an attorney-client privilege discussion and simply allowing the compliance function to operate as it should operate, to show that you have an appropriate audit and reporting and monitoring and whatnot.
All right, this is our Stark analysis checklist. So, Ed, you want to speak to this one as well?
Yeah. So, you start questions. The key analysis first is there a physician involved? Because START applies to financial arrangements between a physician and an entity. So if there's no physician involved in the arrangement at all, then there's no START issue. And then also, or physician organization. And then it says physician, if there is a physician, the physician cannot make referrals of designated health services to the entity, and that entity can't bill for those designated health services. So the really next question, there's a physician involved. Does that physician actually refer the list, any of the 10 types of designated health services that are listed in Stark? Okay, so let's say you get now that check. Yes, there is. Well, are those, this is a Medicare statute, or in some states they refer to it as Medicaid, some instances Medicaid. So are they referring services, but they're not Medicare or Medicaid services? No, there's no payments made. And again, I want to stress referrals. It's not just referrals under the arrangement. It's any referral that physician makes to that entity, usually the hospital. So if they're not making referrals under that arrangement, but they're making referrals elsewhere, then Stark does apply. So if these are Medicare payments involved on the designated health services, then you might have a Stark issue because you have a financial arrangement that must meet an exception. So then the fourth element is looking for what are the applicable exceptions. There's a rental space, equipment, employment exception, isolated transaction, incidental benefit. There's all these exceptions that are out there, and you have to meet each of those elements. So you figure out which ones apply. There may be more than one. You only need to meet one for that financial arrangement. And then finally, a big piece of that is many of these have fair market value. Is that financial arrangement fair market value? And then you want to ensure the compliance checks are done for it all. But that's sort of a quick and dirty of what the attorneys are doing when they're looking at Stark. And again, what the administrators need to keep in mind as should there be a potential Stark issue, and they need to make sure that they're getting counsel so that their financial arrangement, or they have a template system in place, those financial arrangements are compliant.
All right, so this slide is about don't get blindsided, right? So you as in-house administrators or as legal counsels, you want to keep yourself from getting blindsided. And the way we've always viewed it is know your environment, know where you are, understand the documents that are making the business flow. So you start off with actually corporate governance documents. You want to take a look at the bylaws, the charters, and so forth, like we had talked about it earlier. You want to take a look at the shareholder agreements and the buy-sell agreements. And Ed made a really good point of this. He's like, you want to take a look at IRS application 1023, because in there you're going to have all of the attributes why something was a not-for-profit entity. That's if you're a not-for-profit entity. Along with it, what you want to look at is what are some of the major contracts affecting my organization. Part of that is going to be the employment agreements that you have. You want to understand that even though you may have 1Z, 2Z employment agreements for 100, 200 different physicians, you want to understand the template well enough to make sure that you're able to actually give quick thoughts and opinions on it. You want to take a look at the ongoing acquisitions that you've got going on, the payment structures that are in play. You also want to know, for legal counsels, what are the outside legal counsel rates? What are you paying to other law firms that you might want to know about? Because somebody's going to come to you and say, hey, you guys are overspending. Along the way, you want to understand management agreements, the major space leases you may have. Maybe you're leasing something out, or you're leasing something for yourself, for your organization. And you also always want to keep abreast of like the latest and ongoing construction contracts, because that's where the future is, right? So the CEO and everybody else around you has their eye on those construction projects that are going on. Ed, you want to speak as to employment law?
Yeah, I mean, looking at this checklist, these are the sort of things you're walking down the hall that you may just get a question on. So having understanding of wage and hour law is important because these entities are employing people. And you know, you may let's say, for example, you're employing doctors, and you may have overpaid a physician, and you have to understand your state law. Can you actually simply take that money out of their employment pay to true it up? Because the state law may not allow you to do that. Those wages, you may be required to do that, and have a lawsuit for it, but you may not be able simply to take out it from your the employment arrangement, the paycheck. You know, so understanding the whole issues of a hostile work environment, restrictive covenants, all those employment laws, it's very important for a counsel to understand, because those play an important part of the day-to-day questions that may come up.
You know, the other interesting thing that actually Ed always urges all of us to do this, which is to take a look at the OIG work plan. You know, you got to take a look at your corporate compliance program, and then take a look at the OIG guidance that's out there in terms of what they will be looking at in the upcoming year. And that becomes really important, because that'll tell you what the OIG is honing in for. So you better go and sharpen your axe on that one and make sure that you've done the things that you need to. Last but not least, you've got to take a look at you should have a wherewithal of the licenses that your organization has, and with the actual different state agencies that they have it with, because that's going to tell you where your problem points are, right? That's what's helping you stay in business. And if something arises as it relates to any of those licenses, you want to be on it. Another thing that I will add to this that's not on this is a list of litigation cases that you are actually litigating, the conflicts that are going on. Know about that, because as general counsels or even in-house administrators for a particular case, you may be asked questions. Hey, know the ins and outs of what's going on in that case. Now, if you notice,
let me make a real quick, as we're ending our talk, I want to point on how important that is. I dealt years ago with a physician group that we were acquiring. An entity was an entity, and one of my clients was acquiring. But that entity in another division of it was involved in a lawsuit involving that physician organization. Was a third party was suing the hospital and the physician organization, but the people involved in the acquisition were not involved, did not know about it. So that if you actually knew about it, because you're communicating, we could have put in certain reps and warranties into that transaction document that would have helped when there was an award. So the shifting the risk over to that physician organization, if you were going to do that. So it's important to have that communication on lawsuits, major lawsuits.
well, I think we went over time by a little bit. Sorry about that, guys. But if anybody has any questions, I know we're a little short on time here, but you're welcome to call us or email us. If you want us to actually review any of your key documents, we'll happily review them for you. And if you need any work done, we'll even give you a legal estimate fee ahead of time before you engage us. So, you know, with that said, if you have any questions, feel free to reach out to us. Our initial review and opinion doesn't cost you anything.
Great. Ben, Ed, Kamal, I appreciate you educating the group today. And if there are any questions, you can, we're running late on time and we want to keep it to an hour. Just go ahead and you can email myself if you didn't get Ben's email, and we'll forward it to him and he'll get back to you with some answers. We will, I guess, are we able to send the attendees a copy of the PowerPoint and the video?
Sure,
okay.
Sure, yeah.
We'll do that in the next day or so. We'll get that out to you so you can have that for your file. And the video, if you want to recommend it to anybody, will be up on my website and Ben's website probably within a day or two. So with that, I appreciate it. Other things coming up next week, we have a networking event on Thursday, this coming week, the following Thursday. And we have another lunch and learn 2 weeks from today. So again, I appreciate you coming on. It's a little after 1 o'clock. Don't want to keep you much longer. Thank you very much. And we'll see you next time from Healthcare Law Partners and South Florida Hospital News. See you next time.